My colleagues have been telling me that I've been looking very serious in podcasts, so I've decided to try and smile. The topic I will cover in this podcast is in rejection of plaint. Can documents filed with the plaint and documents referred to in the plaint but not filed be considered? Order 7, Rule 11 deals with rejection of plaints. All of us know that when rejecting a plaint, the court can look only into the averments made in the plaint and cannot look into the case made out by the defendant, either in his application under Order 7, Rule 11, the affidavit filed in support, or the written statement. This being the background, the question I will address in this podcast is whether the documents filed with the plaint or the documents referred to in the plaint can be considered by the court when deciding an application filed for rejection of plaint. It is necessary for this purpose to also see Order 7, Rule 14, which provides that if a plaintiff sues upon a document or relies upon a document, he should produce the said document with the plaint. A conjoint reading of Order 7, Rule 11 and 14 would indicate the court can look into documents filed by the plaintiff with the plaint for the purposes of determining the application for rejection. In Liverpool and London SP versus MBC Success, reported in 2004, 9 SCC 512 at para 142, it was held that where the plaintiff not only annexed documents to the plaint but also produced a large number of documents with it, the court, considering the application for rejection, was required to take into consideration the documents annexed to the plaint and also the other large number of documents produced with the plaint. The next question is, where the plaintiff refers to some documents in the plaint but does not produce them, what would be the position? In Church of Christ Charitable Trust and Educational Charitable Society versus Ponniyamman Educational Trust, reported in 2012, 8 SCC 706, at para 18, the Supreme Court held that where documents were neither filed with the plaint nor the terms of the document set out in the plaint but referred to in the plaint, these documents which were referred to in the plaint only were to be treated as part of the plaint as being part of the cause of action. The Supreme Court further noticed that it was settled law that where a document is sued upon and its terms not set out in the plaint, but the document was referred to in the plaint, the said document gets incorporated by reference in the plaint. A similar view was taken by the Supreme Court in US Sasidharan versus K. Karunakaran, reported in 1989, 4 SCC 482, and Manohar Joshi versus Nitin Bhavrao Patil, 1996, 1 SCC 169. Now, these judgments make it clear that a court, when considering an application for rejection of a plaint, not only looks into the plaint, but also looks into the documents marked as annexures to the plaint, also can look into documents produced along with the plaint but not marked as annexures, can also look into documents which are referred to in the plaint but not produced. I am of the view that in view of the aforesaid position, there is one more aspect which needs to be considered. Where the plaintiff refers to a document but does not produce them, the defendant could call upon him to produce the documents. And if the plaintiff does not produce the document or denies the document or neglects to produce the document or refuses to produce the document, it does not appear to me that it would be wrong for the defendant to produce the document referred to by the plaintiff in the plaint and ask the court to consider that document also for considering the application for rejection of the plaint, because that document, according to the Supreme Court, was incorporated in the plaint by reference. This would be useful in many cases where repeatedly we say only the plaint averments, and somehow we seem to have lost track of the fact that along with the plaint there are documents annexed documents produced, documents referred. It is in this context that I made this podcast.